was going to do this oral argument, and his entire family came down with the flu. So
Thank you. Yes, we were informed of that, Ethan.
okay,
We appreciate your letting us know about that. And I know you're on the
and
brief, so
I just checked with him. I'm going to cover his argument this afternoon as well.
thank you
So
for doing that.
no trouble. Thank you, Your Honor.
Welcome to this morning's session of the Kansas Supreme Court. My name is Catherine Gardner. I'll serve as the presiding judge today. And with me today are Judges Tom Malone and Angie Coble. We appreciate your flexibility in moving this to a remote recording instead of traveling to Wichita today in this weather. So we thank you for that. Your case is set for 15 minutes, and so I will go ahead and call the case of 127098, the state of Kansas, appellee versus Kristen Dreyer, appellant. Take appearances, please.
Good morning, Your Honor. Lindsay Cornegay from the Kansas Appellate Defender Office on behalf of my client, Kristen Dreher. Your Honor, with the court's permission, I'd like to request 3 minutes for rebuttal.
Yes, you may have that. Thank you.
Thank you.
And for the state?
May it please the court, on behalf of the Kansas Solicitor General's Office, Ethan Ziff-Sigler.
Very good. Appellant, you may begin.
Thank you, Your Honor. Just to give a brief factual background of this case, a jury convicted my client of forgery, theft, and identity theft. At trial, the state argued that my client fraudulently cashed a check at the drive-through window of a bank, and my client argued that she was 50 miles away from the bank at the time that this check was cashed. I'm primarily going to focus my arguments on issue 1 in a brief, which is the best evidence issue. And unless this court has any questions, I would submit the remaining issues on the brief. So in terms of the best evidence issue, identity was the key question for the jury. And to prove identity, the state took 2 photo surveillance stills from original surveillance recording and admitted those photo stills, but they didn't actually admit the surveillance recording itself. And my argument is that violates the best evidence rule. The purpose of the best evidence rule is to make sure that we're offering the jury a fair and accurate representation of evidence. And in this case, we don't know if the photo surveillance stills were an accurate representation of the recording itself. And we're going to be spending the majority of our time, I believe, looking at KSA 60-467, which is the codification of the best evidence rule in Kansas. And under subsection A of that statute, the proponent of evidence has to admit an original writing or recording if they're trying to prove the contents of a piece of evidence. And my argument here is that the state was trying to prove the contents of the original surveillance video by offering these photo stills. And again, that runs afoul of the best evidence rule.
Sorry, I'm sorry to interrupt you, but doesn't that same section say, unless these rules are, provide otherwise, and then the very next section says a duplicate is admissible to the same extent as the original, unless a genuine question is raised about the original's authenticity, I'm not sure that a genuine question was raised about the authenticity. And so I guess that would be my question for you is, given the rules discussion about duplicates, how does that affect your analysis?
Well, Your Honor, that subsection of the statute, subsection B, states that a duplicate can be admitted if there's no genuine question about the authenticity or the circumstances make a duplicate unfair. And my primary argument is that the circumstances make a duplicate unfair because we're missing a lot of context from these surveillance stills. So again, you're correct that that subsection of the statute does say, there's no genuine question raised about an original's authenticity that makes it okay to admit a duplicate. But there's also this alternative provision of the statute that says, or the circumstances make a duplicate unfair. And that's really the primary focus of my argument, is that we don't know the rest of the context of the video, and that makes these photo stills unfair because we're missing an entire 20 to 30 minutes of this video that could provide different context for the photo stills.
Let me ask you more factually about that because I'm having a hard time conceptualizing what is it, for example, that the context could show as to her identity that would make the duplicate unfair here.
Well, Your Honor, I think that's the primary question in this is that I don't know. I don't have a good answer to that question because we legitimately just do not know what the rest of this video shows. The state was never in possession of this video. They never subpoenaed this video. They never turned it over to defense. So to answer your question, I don't know. And I think that's the entire point of this argument. And just to put this in a different context, say you have maybe a battery case where there's a photo still of a defendant punching a victim, but then there's a whole surveillance video from which those photos are derived showing the defendant was acting in self-defense. So in that example, in this world I'm building where we know what's going on, you do have a problem there where you're missing this huge context in the video of this self-defense question. And here again, I just don't know the context of the rest of the video, and defense counsel at trial didn't know, the state didn't know, the court didn't know, and that's really the issue that we're facing in this case.
If your client's defense was an alibi and she wasn't even there, then because of that defense, I'm having difficulty finding that your client was prejudiced by these two photographs. Can you elaborate on that?
Sure, Your Honor. I just think that a video can show you much more than two photo stills from that same video. For example, it might be the angle of the video makes it look like my client, but there might be certain other circumstances in the video. Maybe the way my client is moving, maybe it's just, maybe the video is zoomed in. We just don't know the entire rest of the context. So again, you're right that my client did have an alibi defense, and just, the main question at trial was identity. And maybe there's something in this video that shows something that we're not seeing just based on the photo stills. And moving on to some of the other issues in my argument, there are certain subsections of the statute that we're dealing with, it's 60-467, that allow either a duplicate or excuse offering the original recording. And my argument is that none of those exceptions in the statute apply. For example, if the video was somehow lost or destroyed, that would excuse a original recording, but the state did not meet its burden as a proponent of the evidence to show that that was somehow excused on that basis. And just looking at some of the other subsections in that statute, the state has not proven that any of those apply, so we can't apply that to this case.
Is your argument then that a duplicate would always be unfair since you don't have the context?
Well, Your Honor, I guess the question is if the proponent of the evidence is also, like in this contest, also admitting the surveillance video. In this context, I think it is unfair because the state is admitting these photos as a duplicate of the surveillance video. But in other contexts, like in the Dale case from the Kansas Supreme Court, it would not be a duplicate to admit something derived from a surveillance video if you're also admitting that surveillance video itself. For example, in the Dale case, you have an original surveillance video and you have a slowed down version of that video. And the Kansas Supreme Court, in its holding, said that that was not a violation of the best evidence rule because the state was not admitting that slowed down version of the video as a duplicate. So my argument is that it's not inherently prejudicial to admit a duplicate, But because the circumstances here are unfair, where we don't know the context of the rest of the video, that's why it's unfair in this circumstance. And Your Honor, I guess just to maybe wrap up or get closer to the end of my argument, I wanted to talk a little bit more about some of the cases that we cited in this case, in the briefs. For example, with Rodman, there is no best evidence rule error when a photocopy of a drawing was admitted instead of the original. And the court held that way because because you weren't getting any additional information from a duplicate copy of a drawing. You are getting the exact same probative value as the original, and that's why it was okay to admit a duplicate in that case. You were not getting any kind of extra content admitted. It was just that duplicate was a fair representation of the original. Unless this court has any questions, I'd probably just conclude my initial argument and turn it over to the state.
Very good. State, you may proceed.
Thank you, Your Honor. May it please the court. I think what I go back to mostly with this case is that I don't think this issue has been properly preserved for appellate review. While I'm aware that there was an objection at the trial level that said best evidence rule, when you dive into the argument that was actually being made at trial, it ended up being an authentication argument and a discovery violation argument. And that's what the parties argued, and that's what the evidence ended up being presented as. And I just don't think there was sufficient chance for the district court, the state, and the defense to fully litigate the issue of best evidence before the trial court. So when we talk about the duplicate, whether the duplicate is unfair or not, those arguments weren't made below because it just wasn't an actual best evidence rule objection. It ended up, those words were used, but in the context, it was very clearly a different objection that was lodged. So I just don't think this court is in a position to make a judgment call on the best evidence objection here because that issue wasn't fully litigated before the district court. As to going on to the merits, Dale is an interesting case because Dale was the first case that raised the issue that videos are writings at all. Before Dale, this court had found that videos aren't writings by the plain definition of the statute, and then Dale changed that. The 2021 amendment that added subsection B on duplicate seems to be a direct response to Dale, and it seems to be a way of saying, look, things derived from video, duplicates, are admissible as the original. And this is particularly important when we talk about the modern day context, because while the defense argues that the photos are a duplicate, the truth is that the video is a duplicate in this case. This is a fully digital piece of media. There is no physical copy. Previously, when we talk about videos, we're usually talking something that was directly burned onto a DVD, so that there is a digital original on a DVD that could be actually admitted. But now we're not talking about that. A DVD in this case is a duplicate. The original is on a hard drive. It is in binary. There is everything is a duplicate of that original. So there is no functional distinction between the stills and the video in this case because it's all a derivative of digital binary that is on a hard drive, not on a DVD. So we're in a stage where you really start to understand why the 2020 amendment had to happen. Technology was changing. We no longer have videotape or DVDs. A lot of our videos, a lot of our images are going to be based in hard drives on computers. And so it really does end up being that determining what is the original or what is a duplicate becomes almost impossible. So we had to have a fix. And I think after the 2021 amendment, it's clear anything that's derived from the original binary on a hard drive somewhere is a duplication, is admissible unless one of the two exceptions apply. That there is a genuine question as to authenticity, or it is genuinely unfair to allow the duplicate. And I don't think that was fully litigated below. And even if this court were to consider for that for the first time, as Your Honor, Judge Malone points out, the defense was alibi. So there isn't a lot of context that could change. The arguments that, well, maybe from this angle or the stills, it could have looked more like the defendant, is an argument that was made and to the jury, and the jury rejected. So I think those are evidentiary issues, and those evidentiary issues were considered by the jury, and the jury rejected them, and that is just how this should be handled. I believe there wasn't an error admitting the video, and I believe the conviction should be affirmed. And unless there is anything else, the state would stand on its brief.
Thank you, counsel. Appellant, you have 3 minutes.
Thank you, Your Honor. First, I wanted to address the arguments on preservation. Respectfully to the state, I'm a little miffed on the preservation argument because defense counsel explicitly raised this as a best evidence issue twice during trial and implicitly raised it as a best evidence issue once more. Just a quote from the record, the first objection was, "Your Honor, I would object on grounds of best evidence as well as foundational purposes." And that's from volume 8, page 100. And objection 2 is that, and that is my objection as to best evidence, Your Honor, which is from volume 8, page 114. And finally, implicitly referencing the best evidence objection, defense counsel said, "I would just reiterate my prior arguments from volume 8, page 128. And KSA 60-404 requires a litigant to raise a timely and specific objection. And defense counsel clearly did that in this case. The state is saying that defense counsel changed its argument during some of the voir dire on this issue, but I would argue that defense counsel's argument is contained within a best evidence objection because some of the voir dire issues were, was this evidence in the state's possession? And if the state never possessed this video, if it was unprocurable through the court's processes, then that would be an exception to the best evidence rule. But the point is that this was absolutely preserved per KSA 60-404. And again, I disagree with the state on that. Addressing some of the merits of the arguments, I guess more than anything, I would worry about the precedent that would be set if we allow photo stills from a surveillance video without also mandating that the surveillance video is required in terms of best evidence. Because again, looking back to my previous example of self-defense, if you have just this one still in time of a defendant punching a victim without the rest of that context of that video, you're missing so much information that changes the entire course of the trial. And in this case, we have 2 photo stills derived from a 20 to 30-minute surveillance video. And we don't know the rest of the context of that video. And the state is saying that these photos are a functional duplicate of that surveillance video. But again, the point is we don't know the answer to that question. We don't know if that's a functional duplicate of the video. And again, that's why this issue is a best evidence issue. We don't know if these photo stills were fair or not. So I conclude my argument on that point, and I am asking the court to reverse this issue and remand for new trial. Thank you.
We thank both counsel for your good arguments today. We will take this case under advisement and get you a written decision